Hello, my name is Riccardo Sabato, and I am a judge for civil matters in a court in Basilicata, a region of southern Italy. I will say a few words concerning the relationship between the legal framework of my country, especially civil proceedings, and the developing international and European frameworks in the area of artificial intelligence. Starting from the international framework, we must remember that in 2024, the first ever international legally binding instrument addressing AI was adopted. The Landmark Frameworks Convention on Artificial Intelligence and Human Rights, Democracy and the Rule of Law. It was prepared in Europe at the Council of Europe, but it was opened for signature for states from other regions of the world. It has been signed by Israel, the United States of America, Canada, Japan, as well as by the European Union. The Council of Europe, through several of its bodies, adopted also a series of non-binding instruments which occupy several pages of their website and that, of course, I cannot mention. However, the European Commission for the Efficiency of Justice adopted already in 2018 the well-known European Ethical Charter on the use of artificial intelligence in the judicial system and their environment, and now in 2025 issued the assessment tool for the operationalization of the European Ethical Charter on the use of artificial intelligence in judicial system and their environment to promote responsible use of AI in European judicial systems. Also, the important Council of Europe Steering Committee for Human Rights has been tasked with the preparation of an handbook on human rights and AI by the end of 2025. And another working group on cyber justice and artificial intelligence has been issuing several documents accompanying states and courts in a successful transition toward the digitalization of justice. Then, of course, we have at a different level on the European Union Regulation EU 2025 1689 of 13 June 2024, laying down harmonized rule on artificial intelligence, the so-called EI Act, on which we have said a lot here in Capri in the past and will not add anything more. I will only note that both the Strasbourg Convention and the EI Act, indeed, have inspired each other. So they're expression of the same political legal approach, and the core points of both appear to me to be twofold: the role of risks and the role of ethics. Indeed, especially the URI regulation tell us a lot on risks, while the Council of Europe Ethical Charter and other texts tell us about ethics. The EI Act classifies EI according to its risks: unacceptable, which is forbidden; high risk, which is regulated; limited risk, which is only subject to transparency. Justice is at level of high risks, for example. And for ethics, the main ethical concept is, of course, human control, as clarified in particular in the CEPE Charter. Italy's law number 132 of September 23, 2025, effective from October 10, must be read in this context. It's a national framework that integrates the EU AI Act, while addressing local priorities. The legislator has adopted an anthropocentric approach focused on safeguarding the centrality of human being and human oversight in decision-making process involving artificial intelligence systems. As for public administration in general and judicial activity in particular, the use of artificial intelligence is aimed at increasing efficiency, reducing procedural times, and improving service, with AI being used purely as a tool to support public officials. Similarly, in judicial activity governed by Article 15 of the AI law, any decision on the interpretation and application of the law, the evaluation of facts, and the adoption of measures is always reserved for the judge. Notably, Article 17 amends Article 9 of the Civil Procedure Code, assigning exclusive jurisdiction to the courts for cases concerning the functioning of an artificial intelligence system. I will conclude that this context of the Italian legislation appears to me translating into interesting local rule the concept of risks and ethics I mentioned before. The challenge we have before us is now the application of this concept in the area of justice. The ministry having now a new department competent for innovation, which is so called to important tasks. We are not merely dealing with the need to avoid a judge totally governed by AI, but defining where we want human processes and where we apply just with human oversight. We have to study all the implications of AI for procedural fairness in civil and in criminal law. To what extent will machine support or disrupt the core tasks of judges, lawyers, and other humans? Thanks for your attention.